Now, for thousands of years, not starting in Egypt, but also in Egypt, the figure of justice has been and is a female figure. And I see that Themis, the Greek goddess of justice, is the symbol of your university. Terrific. And she holds the Constitution of Kazakhstan, I believe. I want to talk to you about our arbitration center and put it in context as well. Many years ago now, one of the great commercial judges in England said that the London Commercial Court is the Curia Franca of the world because everyone chose to resolve their disputes there, even if they weren't English and it wasn't even English law that was applicable. They just chose that jurisdiction. Now, today it would be fair to say that individuals and entities choose arbitration in ever-increasing numbers to resolve their disputes. And many reasons can be stated for this, and the emphasis of what is considered particularly important varies. But the list usually includes immediate accessibility, privacy, confidentiality, choice of arbitrators, control of proceedings, relative speed, relative economy. And I will expand on some of those hereafter. Now, responding to this growing demand, arbitration centers have sprung up in new places all over the world, and existing ones have grown mightily. Astana sits at the heart of a vast and wonderful region, a region that so far, though, has not had an arbitration center. There has certainly been a very significant use of arbitration services by parties from this region, but they went far afield to go to their arbitrations, not least to London. Now, recognizing this trend and its importance, forward-thinking leaders here have responded. And Article 14 of the Constitutional Statute of the Republic of Kazakhstan of the 7th of December 2015 established the International Arbitration Center, and the AIFC arbitration regulations of 2017 provided the legal framework. Regulation 48 emphasizes that the center shall be an independent legal entity and shall, I quote, provide an independent and expeditious alternative to court litigation to resolve civil and commercial disputes. The center began its existence on the 1st of January of this year, and since then we have published our own arbitration and mediation rules. We have assembled a panel of outstanding arbitrators, and this panel is still being built up. And we have published a fee structure, economic fees, and we have designed a website, and very importantly, we have set up a users committee in order to be able to listen to those who use our services in order to improve those services and, to the extent appropriate, amend our rules. And in all these matters, we have been greatly assisted by tireless, and I hope not too often sleepless, dedicated staff trying to make this garden bloom before it has barely been planted. Firstly, they are prefaced by an overriding objective which applies throughout. It's Article 2.1, and it reads, "The overriding objective of this part of these rules is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay and expense." Secondly, our rules are characterized by flexibility, which I will develop. And thirdly, they are intended to be adapted to what our experience and our users will tell us would be desirable, adding changes as and when that appears appropriate. They are not cast in stone. They are meant to be an organic creature. Now, speaking about the flexibility aspect, arbitration is all about giving parties the service they expect. It is about party autonomy. The jurisdiction of arbitrators is exclusively based on the parties' agreement. Now, exactly what an arbitration agreement, an arbitration clause in an agreement means is not infrequently a matter of dispute itself. There are numerous cases where people, when an arbitration starts by a request being put forward, decide to argue about whether the arbitration clause applies, whether it was incorporated into the agreement, whether the agreement itself is valid, induced by fraud, or something else. There is a principle in international arbitration law which has existed for a very long time called Kompetenzkompetenz, German, and it means that arbitrators invariably have jurisdiction to decide upon their own jurisdiction. Does it exist? Is the agreement valid? Is the arbitration clause valid? And so in our rules, we provide also for Kompetenzkompetenz. And I come back later to the role of the court in relation to it. But we have made it possible in our rules that if the parties agree and a third party, an outsider, agrees, then additional parties can be joined. This is an extremely important development in arbitration work. It used to be absolutely limited to those who had agreed to arbitrate in their contract from the outset. But frequently this caused a multiple set of proceedings and much difficulty and much expense. And I give you two examples. One is you have an insurance contract between an insurance company and a reinsurance company. The broker who has arranged this cover is not a party to their agreement. However, both blame him. Now, what do you do if he is not a party to the arbitration? He can be joined, obviously with his agreement, but it so happens that people normally do agree because it saves a multiple set of expensive proceedings. You also frequently have chains of contracts, chains of delivery contracts, chains of sale contracts with different parties and different arbitration clauses. Again, you can now agree that others should be joined to just one arbitration, but equally you can now agree that a new arbitration be consolidated with an existing one, so that you save a great deal of time, a great deal of cost, and inconsistent results. And these flexible arrangements of joinder and consolidation are in our rules. We are also flexible when it comes to how people can be represented at arbitration proceedings. They can represent themselves. They can appoint anybody they wish to represent them. It does not have to be a qualified lawyer. It can be anyone whom a party trusts to speak for them. And as I say, they can do it for themselves. Now, it's fair to say that in the large commercial disputes, usually lawyers are chosen, but it is much, much less formal than in court proceedings. And also the arrangement, as you will doubtless have learned by now, of an arbitration is that here's a panel sitting at the table, and then there's a long table, and the parties sit opposite each other and looking at each other. They are not at daggers drawn in different parts of the room. Now, the venue of an arbitration hearing, again, is something that the parties and the arbitrators can choose. You would have, if you are in Kazakhstan under our rules, the seat of the arbitration being Astana, and that means supervisory court is our court, the international court here. However, it doesn't mean you have to have your hearings here. You can have them absolutely anywhere in Kazakhstan or in other countries, wherever it is convenient for the parties to be, wherever it is for them the most economical way to be. And of course, you can have hearings by telephone and by video link. The hearings are normally in private, no press and no outsiders who then go and report on it. It is strictly confidential what goes on in an arbitration. Exceptions exist, but only by agreement between the parties and order of the tribunal. Otherwise, confidentiality seriously reigns. And the idea that whatever you then get off your chest during the arbitration might be read in tomorrow's newspaper, no. It certainly shouldn't happen. The language of the arbitration will again be chosen by the parties and the tribunal, and among the arbitrators whom we have put on our panel are people who speak a whole variety of languages, various European languages, many Russian speakers, Chinese speakers. It's crucial that people should be able to deal in their own language, that they should be able to listen to experts in the language of that expert, that they should be able to access documents in their language. When it comes to the law applicable to an arbitration, the law is frequently laid down in a contract, and the arbitration clause itself frequently says what the applicable law shall be. But sometimes that is not the case, and parties just haven't agreed it. In that case, the arbitrators are able, under our rules, to choose what is the most appropriate law to apply to that dispute. Under our rules, the tribunal has very extensive powers. And they can, for example, contrary to what used to be the case in international arbitration, grant an injunction. And they can grant emergency relief. The tribunal can also, and again this is a new development under our rules, grant what was called summary judgment, a summary determination, so that if you have a situation where you can see immediately that a claim is hopeless, or that a defense put to a claim is hopeless, or that part of a claim or part of a defense are hopeless, the tribunal can be asked to deal with that immediately and to get rid of the hopeless claim and the hopeless defense. Saves a huge amount of time and expense. Of course, at any stage, the parties can reach a settlement, and the tribunal can then, if asked, grant a consent award, or can just be informed that the parties have reached a settlement and the tribunal is free to close the proceedings. In cases where the value of the litigation is less than $5 million, the parties can request, under our rules, an expedited procedure, if they agree this, or when there is exceptional urgency, they can ask for the procedure to be expedited so as to respond to that emergency. But again, in the newest development, which we have introduced into our rules, you can now ask for an emergency arbitrator before any tribunal is formally set up, each party having chosen an arbitrator, I as chairman of the center having appointed the chairman of the tribunal. Before these proceedings have even started, before a tribunal, then we can be asked, I can be asked, to appoint an emergency arbitrator to grant an emergency injunction, for example, so that you can respond immediately. Something has gone wrong in a business. You have to stop the employee to leave, stop him from leaving with confidential information. The emergency arbitrator comes in. So there is a great amount of flexibility, of which I have given you only examples. There are also two particular important matters of freedom of choice and flexibility. Firstly, the parties can come to our center and ask our center to administer the arbitration, to deal with the arbitrators, to hold the necessary funds, But they may, for some reason, not want to do it under our rules, perhaps because they've already agreed in their contract that the other rules should be applied, for example, the UNCITRAL rules, or they can have ad hoc rules that the parties have agreed. So our centre will administer arbitrations which are not under our rules. We hope, of course, that people on the whole will apply them, because they have been tailor-made, we hope, for everybody's demand. However, we are prepared and flexible when it comes to what rules should be applied. The party autonomy means that the parties decide exactly what it is that the procedure should be. And that includes the appointment procedure for the arbitrator. Now, each party normally, if you have a biggish case and you will have 3 arbitrators, appoint their arbitrator. If they don't know somebody, or if they think our panel includes the best people one could find worldwide, they can choose somebody from our panel. But they can bring somebody forward whom they trust and whom they already know. And I will then appoint the 3rd arbitrator, who is the chairman. And as I've already said, we have been very careful to choose arbitrators who are particularly experienced in the kind of work that might well come to our centre. So we have people who have dealt with oil and gas arbitrations for many years, with investment disputes between states and companies, with construction issues. They have been chosen also for their linguistic skills, and every one of them is what is crucial for any arbitrator to be: absolutely independent. So every time an arbitration begins, then a party will put forward an arbitrator, say, or we choose an arbitrator from the panel. That arbitrator will be asked before he is appointed, are you independent from all the parties? The arbitrator will have to be told who the parties are on the other side. Has he worked for them in the past? Is there any kind of existing relationship which could cause a conflict? The independence is absolutely crucial. And the second question that is always asked as well is, are you available? Because the whole point of arbitration is that it should be accessible and speedy, and not, oh, somebody is so busy he can't hear anybody until next year. I have said that I will also speak about the court and its role, and that role is laid down under the arbitration regulations, who are the law in this country, and Regulation 13 says that the court shall not intervene except to the extent provided for in the regulations. And the regulations then very clearly set out the cases in which the court will assist the arbitration or supervise the arbitration or deal with things that have happened in the arbitration. So I give examples here. They are actually quite exclusive examples. Under Regulation 22.3, say an arbitrator has been appointed, it emerges after he has been appointed that he isn't actually independent. Some conflict has come out, or somebody thinks there is a conflict. The first instance of dealing with that challenge is, again, the tribunal itself. The tribunal will then decide, is there a conflict here? Assume the tribunal says, no, there isn't. This is fanciful. We don't agree. This arbitrator should stay. Then the party who has presented the challenge is free to go to the court and to say to the first instance court, we have challenged the arbitrator, the tribunal didn't agree with us, please court, help us out. Secondly, I have already said, under competence, tribunal decides whether it has jurisdiction in the first place, if there is a challenge to its jurisdiction. And if the tribunal decides it has jurisdiction and the party challenging the jurisdiction is not satisfied with that result, that party can go to the court and say, to the first instance court here, this is my appeal from that decision of the tribunal. We maintain the tribunal does not have jurisdiction. However, the court also acts in support of the existing tribunals. It can enforce interim orders, for example, injunctions, because it is possible for arbitrators to make a whole series of rules under their powers, but the arbitrator isn't the state, doesn't have the support of the state, and cannot deal with enforcement, can only make the orders. If any parties then don't comply with them, the state has to come in by dint of its court and enforce. And that applies to awards. As you know, that awards are portable worldwide. You can take your arbitration award and enforce it under the New York Convention in most countries in the world. That makes arbitration awards extremely valuable and often better than a judgment from a court, because court judgments are subject to reciprocal arrangements between countries, sometimes easy to enforce, sometimes not. However, equally, it is usual in many countries, including England, and now here, for an arbitration award to be recognized and enforced by the relevant court, which here, of course, is the International Court, and then it becomes the judgment of that court in addition to being an award. And then that enables enforcement in the country with entire enforcement machinery that exists, and further, it can travel in those places where judgments of this court are recognized, in addition to being an award, being a judgment, which is also very important. When it comes to the award, that can be set aside on application of a dissatisfied party, but on very, very limited grounds, which are set out in Regulation 44. And those are the same grounds under which you would be unable to enforce an award under the New York Convention. And the reasons are reasons like there never was an arbitration agreement. There were the most serious procedural irregularities. The arbitrators didn't even sit. A party wasn't notified of the existence of the arbitration. Party was under an incapacity. So in very serious matters of this sort, the court can then intervene and set aside the award, or uphold it, of course, if the grounds that were mentioned are not made good. Now, the commercial judge whom I cited at the beginning of this talk also said that commercial litigation should be a joint venture between the parties. In other words, they should always cooperate, assist the court, and not fight like enemies in the field. However, in our experience, this is not often the case. There is usually a great deal of adversity in most litigation. It has been my experience, though, that in arbitration this can be different. I have been involved in numerous arbitrations where parties are engaged in business with each other, and I gave the example of insurers and reinsurers. They have every intention of continuing in business with each other. The same is true of commodity trading. The same is true of delivery contracts. They want to stay in business with each other, but they do have a genuine difference of opinion, different advice they have received as to what a contractual term means, what their rights and obligations are. And therefore, they go to arbitration, let the arbitrators decide this. Most of the time, by the way, they accept what the arbitrators then decide, and they continue in business with each other. It is a civilized way of resolving disputes. So when we go out and, as it were, sell the arbitration center and say to you, we recommend arbitration, then we are not inviting adversarial litigation, but we are inviting a civilized way of resolving your disputes. We also have in our rules, rules for mediation. Now, mediation, as you have probably learned by now, is very different indeed, because whereas arbitration is similar to court proceedings in the sense that there's somebody sitting there listening to rival arguments and making a decision. In mediation, there is no decision. The mediator is simply a professional third party, an experienced, able person who can facilitate negotiations, just bring people together and make them see the strengths of the other side's case, the weaknesses in their own, and somehow have a meeting ground. And there, too, we have provided rules which people can choose to use, or they can have other rules, or just ad hoc rules. Again, it's very, very flexible indeed. And mediation is something that can happen in the middle of proceedings. I've seen this not infrequently, both in court proceedings and even in arbitrations, that people suddenly think, okay, we could actually negotiate here. It's even quicker. Negotiations become difficult. The parties have become entrenched. Best to have a mediator who helps them out of the trenches into which they have dug themselves in order to try and resolve that dispute.